Okay, good afternoon, friends, and welcome to Local 17's Town Hall. Today, we'll be discussing the changes that management is proposing to attorney performance standards for fiscal year 2025, which is quickly approaching in about 6 weeks. I'm Doug Massey. I'm the president of Local 17, and I'm pleased to see so many of you here today. Before we begin, I'd like to just give a shout out to some of Local 17's team members who are from the board. We have Colony Kedem, Steve Eckerman, Nick Keogh, J.R. Cummings, Sakina Baxter, Marla Waderick, M.B. Vasilio, Benton Commons, Denise Adams Hill, Andre Washington, and last but not least, Giorgio Kominos, who's in Greece. He's been there for like 6 weeks, so hope he's having a good time. As your exclusive representative, Local 17's responsibility is to negotiate any changes to your conditions of employment, including performance standards. In May 2024, board management informed us of their intent to implement significant changes to performance standards for all decision writing attorneys. And while some of these may not seem like dramatic changes, the natural and probable consequences for many attorneys could be dire. I want to start first by acknowledging the incredible work that you guys do every day. This job is hard. There's no doubt about that. You get a file, you sift through thousands of pages of medical documents, many of which are illegible. You apply complex regulations and constantly evolving case law, all while staring at a computer screen for hours on end. And when you're finally finished, there's a sense of accomplishment. Maybe you've changed a veteran's life, but then you realize the clock is ticking and you must swiftly open up another file and start the process all over again. But this is far from a seamless workflow. You may spend hours on a case only to send it off for some administrative action that yields no credit. You may have to rewrite a decision after not seeing it for days or even weeks. You may have to do the background investigation check that takes anywhere from 2 hours to a day or two. You may like your VLJ, you may have a good relationship, but you're probably painfully aware that senior management is less concerned with the quality of your work you pour your heart and soul into and more focused on the numbers. The board is run by bean counters who primarily care about the bottom line. And all but Bob Scharnberger have never written a single board decision. I would like to say we are heartened to see that there are 2 temporary DVCs, Evan Dykehart and Tracy Westner, who rose up through the ranks. I've heard very positive things about both of them. I know both of them somewhat. I like both of them. And I think those were very good selections. As your team of union advocates, we see the dedication, the skill, and the sacrifices you make to uphold your commitment to our veterans. We are here to support you, to ensure you have the resources and protections you need, and to fight for a system that recognizes and values the incredible work you do. But the deck is stacked against you, against us. But together, as a unified group, we can have an impact. So at this point, I'd like to turn the meeting over. We have some union stewards who are going to discuss. There's pretty much 3 primary elements that everybody should be aware of that are going to impact your jobs, your lives the most. And at this point, I'd like to turn it over to MB Vasilio, who is going to discuss the new proposed productivity element.
And wait, Doug, can you just say she's our new 3rd vice president?
Oh, no, you just did. I don't have to do that. She is, MB Vasilio is our new 3rd vice president.
Thanks, Doug.
Colin Kedem is our 1st vice president.
Our once and future 1st vice president. So I want to talk briefly about productivity. The first thing to understand is they're not proposing a change in the quota. It's still 156 cases, but there are significant changes for what fully successful looks like. And I'm just going to read from their proposal. So fully successful for the period from October 1st through and including January 31st, the attorney produces 52 signed decisions. For the period from February 1 through and including May 31, the attorney produces 52 signed decisions, or when including decisions signed since the beginning of the performance year, the attorney has produced 104 signed decisions. From the period from June 1st through and including September 30th, the attorney produces 52 signed decisions, or when including decisions signed since the beginning of the performance year, the attorney has produced 156 signed decisions. Additionally, for the period from October 1st through and including September 30th, the attorney has produced 156 signed decisions. Those numbers are subject to proration, and the exceptional standard is that the attorney produces 185 signed decisions. So the big change, thank you, Doug. The big change is these three, I would say trimesters, but I think that has a more specific meaning, these 3 periods, and especially the first period. It's too short. The concern that immediately came to mind is, what do we do if you have a slow signing VLJ who's got use or lose leave? Will they be able to sign everybody's decisions in a timely manner? And yes, it does eliminate the issues track. I think this is in keeping with the theme of what you might hear more about for the other proposed standards. Is these seem to be a solution in search of a problem. They want to eliminate the issue track. They want to have these arbitrary checkpoints that don't have a safety valve for folks whose VLJ is signed slowly, have leave, or out on leave. There's no provision for any sort of a safety valve. The issue track, I think what they've said about it, exactly. The comments that I'm seeing in the chat echo the concerns that we have, about it, that there's no commensurate requirement for VLJs. The issue track, obviously, I know I'm sort of preaching to the choir here. We're all decision writing attorneys, but that has, it's a pressure valve for folks, who are not doing the issues track. Yep. Yes, the trimester goals are subject to proration. This just seems to make it easier for them to put people on PIPs and potentially fire them. That seems to be another theme through the proposals. It's especially concerning the loss of the issue tracks. The issue track is especially concerning given that some formerly SCT cases that tend to be high issue, like IRI cases, are being returned to just be distributed throughout the general population of decision writing attorneys. So those are our concerns. I think there are other concerns I'm seeing in the chat that are very well taken. And this is why we're presenting them to you, so that we can hear what your concerns are, so that we can negotiate to try to address them. Thank you, Doug.
Thank you, MB. Just for everybody's awareness, some people have called in. I put a question up on the poll feature, and the question is, I'd be willing to give up the issues track for a substantial reduction in the annual case quota of 156. And so far, what the hell did I do with that? 31% said yes. This is changing. I'm leaving this up so you can still vote. I can't see who's voting which way, and I can't vote myself. So knock yourself out. Don't worry about anybody finding out how you feel. Not that it really matters, but 31% said yes, they'd be willing to give up the issues track for a reduction in the quota. 47% said maybe if the case reduction is substantial. 5% said I don't care. 8% said probably not. 9% said absolutely not. And as MB mentioned, we see there's great value in this because people that get the really complex cases, with a lot of issues, they can't meet the case count. And also that frees up their team members to get the easier cases, and it's been working out. So I'm going to end this poll. I'm sorry. Let me share the results. so you can see what I just saw. Okay, let me go back. Here's another question I want to launch.
So Lisa, I'm seeing some questions in the chat. It is cases signed. So their proposals as they stand right now are 52 cases prorated, even holidays signed, not submitted. And Alexa, I'm not sure they've done one recently. But my understanding is that the average issue per case, like the difference between legacy and AMA, is pretty small, like less than one issue per case.
Okay, I'm sorry about that. Let me issue the other question.
And these are really good suggestions that we can make proposals out of and propose to them. But yeah, no, that is the concern, is having the end of the fiscal year 3 times a year. It certainly doesn't seem to be consistent with the board's claim to value work-life balance.
Okay, this question I just launched, it says, I believe that the annual quote of 156 cases is fair. And I'm going to let this run for another 15 seconds or so before I share the results.
Right, and that's also the returning cases is a concern.
Okay, 20% said yes, the current quota is fair. 16% proposed it should be between 140 and 150. 26% proposed it should be between 135 and 140. 21% proposed between 125 and 135. And 17% said it should be below 125. So 20% say it's fair. Roughly 80% say it should be less, with varying opinions on that. I'm sorry, I'm going to share this again. Okay, just so everybody can see that. Okay. MB, are you done? Should we move on to the next element?
Yeah, I think so. I'm, in the chat, I think people are making a lot of really good points that, are the points that we will probably be making at the bargaining table.
Great. And we are going to post management's proposed performance standards on our website after this meeting. So I know we're going to have a ton of questions about the standards. You'll be able to go to our website, and I'm going to take the link and send it to everybody. So the next element, I believe, is quality. And JR is going
to can I just make one comment before we get on with JR's?
Sure.
So when we post the proposed standards on the website, we'd like ideas from you about proposals we can make. We can talk about procedures and appropriate arrangements. We can't say, no, we're not going to do 156 or whatever it is, but we can propose things like procedures and like arrangements, like, different kinds of proration or whatever. So we'd like ideas on that, because our ideas are pretty comprehensive, but we don't necessarily think of everything. So we'd like ideas from you. But certain things like, we're not doing this, we can't say we're not doing something. We can only modify through a procedure or an arrangement. So we want your ideas, and obviously your creative minds are going to help us. So thanks.
Great. Yeah. And we'll talk about that after we go through all the standards, about what our role is and how we're your voice. We want to hear your opinions, and also where we are procedurally in the bargaining. So next, JR, who is a steward, he's also Sergeant at Arms, is going to discuss the new proposed quality element.
Yeah. Hi, everybody. Unfortunately, the production standard is not the only change that they are proposing. So you're probably all pretty familiar with the current quality critical element because we've had it for as long as I've been here. That says the attorney, for fully successful, the attorney generally meets expectations, and then exceptional decisions consistently exceed expectations. This has been a pretty standard policy for a while now. They felt that that was too vague and they wanted to define that. So the new fully successful criteria for the critical element of quality is the attorney generally meets expectations with no more than 8% of cases rated at level 2 or below in each of the periods from October 1 through January 31, February 1 through May 31, and June 1 through September 30th. So the same, we're using trimester, I don't know, the same trimester periods for quality apply there too. And then exceptional is decisions consistently exceed expectations with no more than 4% of cases rated at level 2 or below. I think they mean that to be annual, since they don't include the time periods there. So I can already see some of the chats coming in. And obviously, the biggest complaint here is that they're putting hard numbers on quality for us. And I don't have any indication that judges are going to be held to quality standards because right now there is no rubric at all. There is nothing guiding judges on how they must rate cases. One of the RFIs that we did in leading up to these bargainings is how do judges break down as far as the grades that they give? And it's probably not a surprise to any of you that the number of twos and ones that are given out fall disproportionately on a small number of judges. Many judges don't give that many ones and twos, and others give a lot more. So if you happen to be assigned to one of those judges who gives out a lot of ones and twos, you are disproportionately affected by this new rigid standard. Another problem with this that we think is that there's no difference here between a 1 and a 2. The whole reason we have a 1 through 5 system is that there are different gradations of quality. And there is a difference between a 1 and a 2. Otherwise, why give a 1 when you can give a 2? Here, it doesn't matter. You could give a 1 or a 2. You could give all 2s, all 1s. It doesn't matter. If they're below a 3, you're going to fail that element and potentially get removed. That is a big, big problem. Is there anything else here? Yeah, I mean, and for fully successful, they break it up into the 4-month periods, and the problem with that is that it's an annual goal. It should be an annual goal. It has been an annual goal. They're proposing to change that too, but we don't live our lives in 4-month groups, in 4-month quadrants. We live our lives consistently every day over the course of the year. And you could have a bad month, a bad 2-month, a bad trimester, and that could ruin your rating and quality for the entire year in one block of time. If you happen to have a bad stretch of cases, you get a bunch of 2s in a row, that not only could that sink your ability to meet the exceptional criteria for that, it could ruin your chance to be fully successful as well. Because there's no indication from what they're proposing. If you were to not meet one of the trimesters, but do okay for the other 2, how would that affect your annual rating? Because at the end of the year, you're giving an annual rating. We don't know. So those are concerns about quality. One of the predictions that we've had, because the union has had a lot of success over the past couple of years, challenging some of their production. We recently won a really big arbitration where they tried to institute a consistently on pace element, and we won on that. And as a result, one of our predictions was that they were going to start hammering down on quality because that's a lot more subjective, and we can't really argue against that. And this is, I think, their first attempt at doing that. I see the chat is going hog wild over this. I'm going to move on to the case management one as well, because I'm talking about that. Unless, Doug, you want
just,
me? Yeah.
No, keep going. Here's the thing about the chat. I'm recording this, and with the recording comes the chat. And what we do is we send this to our web guy, who, if you've noticed our website, it's pretty, I think it's impressive, the job he's done. And he has a way to synthesize the data and come up with the biggest concerns, and we can provide answers to everybody's question, put it on the website. And so why don't we keep going? And JR is going to talk about case management, I believe. Is that?
Yeah. So the baseline for due dates for case management, we're talking about deadlines for cases. It's 30 days for AOD and CAV agreements. It's 60 for everything else. That's not changing. But how you're being rated on it is going to change. So again, the incumbent standard here is fully successful. You're generally meeting expectations. Exceptional, you're almost always exceeding expectations. Again, this has been largely fine for as long as I've been here anyway, but they want to define it further. An important difference here between quality and case management is that there are no more percentages. They're not doing percentages. These are hard numbers here. No matter how many cases you're writing over the course of a year, you could write 10, you could write 20, you could write 1,000. These hard numbers hold. So the new fully successful rating for case management is the attorney generally meets expectations with no more than 2 cases marked as untimely in each of those 3 trimesters. Exceptional is no more than 2 cases marked untimely over the course of the entire year. The entire year. Now, I don't think that there is an epidemic of late cases at the board, but it does happen. It does happen. And the prior standards, the current standards, as they are right now, gave the judge some flexibility, gave your supervisor the flexibility to rate appropriately based on circumstances. Here it doesn't, because what do we all know? If you have a case at 58 days and it's a Friday, you can't write it over the weekend. It's going to expire by Monday. It's going to be day 61. It's going to be late. So in effect, you have to get that case done that Friday at 58 days, because we know that these cases don't toll on weekends. They don't toll on benefit days. They don't toll on sick days. They don't toll when you're on vacation. They don't toll if you have a day of tech issues, whatever it is. There's no give there. And you could end up writing, if you're a super producer and you end up writing 400 cases over the course of the year, you would be a massive asset to the board. They should be giving you all of the awards. But if 2 of those were late, fully successful in case management. No outstanding on the year, your bonus will be limited. That is awfully, awfully rigid. So those are those 2 elements. And I think the pitfalls for each of those are pretty obvious. They're trying to make our jobs harder. They're trying to add specific, arbitrary, and rigid standards here. And one of the phrases that we used in leading up to this town hall, I don't know if MB may have said it already, but these are solutions in search of a problem. I don't see where the fire here, and them trying to create these schemes, I think is ultimately going to hurt the attorneys. So again, to repeat what Doug has said and what MB has said already, we're going to bargain appropriate arrangements and procedures, and we're looking for how these standards will affect you, because then we can get your feedback and include that when we're bargaining the proposals with management. Because I'm sure there are a number of things that we're not aware of, that we may not know how this is going to affect you. If you're a super producer, how having such small numbers of acceptable late cases, whatever they are, might ding you, or what possible solutions you could have for overcoming issues that may have arisen. So we're looking for your input in order for us to make the best proposals that we can. So anyway, back to you, Doug.
Thanks, JR. I'm going to turn it over to Colin Eaton in a minute to discuss the bargaining process, where we are procedurally. But I want to piggyback on what's been said already. I wrote decisions for 15 years before I became a union advocate. And I got to say, I never got a single, we had outstanding, fully successful, and unsat for grades for decisions. I never got one unsat, actually, until I became a union steward. Then I got one, which was bizarre. But before that, I had written for Susan Kennedy, who was a very difficult judge. I liked her very much. She was just really good, very thorough, but difficult. And I think I became a great decision writer because of her. I attributed that to her. And I worked for her for 8 years. And when I got transferred, I remember telling her, like, I want to thank you for not giving me any unsat grades on my decisions. And I know I deserve some, but you didn't do it. And she didn't argue with me. I was hoping she would, like, oh no, but she was like, you're welcome. And that's how it used to be, because writing decisions is difficult. You do the same thing over and over again. You get burnt out. You're going to let some bad ones fly. You're going to miss something. That's just the way it works. But it used to not be like that. And another example, there is a lot of inconsistency about how VLJs grade. Just to give you an example, I wrote for Warren Rice for a little bit. He gave everybody an outstanding unless you had too many typos. So if you had 50% outstandings from Warren Rice and 50% outstandings from Susan Kennedy, back then we had a chief judge who would evaluate people. The person writing for Susan Kennedy would get an exceptional rating in the critical element of quality, but the person writing for Warren Rice would probably just get fully successful, because based on his grading, that wasn't very good. And based on Susan Kennedy, that was outstanding. And the chief judges knew that, and they knew how to properly evaluate people. So it's almost like comparing apples and oranges. Some people are difficult graders, some people are easy, and you can't really have the same system for everybody. You have to allow that. And we don't really have that anymore. We have, I don't know how many decision writing attorneys. We used to have about 300-400. Now I think it's over 1,000. Also, they want to improve quality. So they're like, I know, why don't we come up with a new quality standard and ding people more? Well, that's not how to do it. I mean, really, if you think about this, the new attorneys are in boot camp training for 6 months. After that 6-month period, they're given the same performance standards as everybody else. Why are they not giving a lower quota while they learn the job that second 6 months? People who are struggling, there's nothing offered by management except a performance improvement plan and possible termination. Benton Commons, one of the stewards, and he can't be here today. He asked me to say this, but he helps many struggling attorneys, people who are on PIPs, people who are not on PIPs, but they're afraid, they're having problems. And he will sit down with people and go through how to be more efficient, how to write better decisions. And that's what the board needs to do. If you care about quality, if you really care about quality, it's not a box to check off. It's got to be kind of baked into the entire system, and it's not. The only thing that's baked into this system is they want high numbers. They don't really care how they get it. They don't really care about our finished products. And frankly, you can't really manage any organization and forget about the people who do the work. What they're doing is they're managing graphs and charts and numbers. They're not managing people. And I don't know why. And maybe this job is a job where that's what it's like. Maybe these are not bad managers. They've come here from other agencies. And this is what they're stuck with. I know we have a command and control system at the board where the orders come from the top and everybody has to comply. So there's not a lot of wiggle room to demonstrate leadership skills, management skills. It's more of a whip. And they did have these great incentives last year. People made a lot of money. I think it was a great system. In some respects, in some ways, it can be a bit insulting. You know, all we care about is this. We just want the numbers, and I think it's not a sustainable business model. And it keeps going and going. Bad results on surveys. My understanding is the new all-employee survey result that came in, it showed improvement in the board. However, somebody that understands data analytics said it doesn't really tell the whole picture. I want to stay optimistic, but I think we can affect change if we make our voices heard. And I think we can do that. And we are going to communicate what the survey said. We can conduct another independent survey and get everybody's opinion. One of the things we requested for bargaining is, I don't have this, the names of every decision writing attorney, so I can get their email and email them. I email the members, and I do have a bargaining unit list that was given to me 2 years ago, but it's not accurate. And some people aren't members, but we do represent them. And so with that, I want to turn it over to Colleen, who is probably one of the leading experts in the country on how to understand the federal labor management relations statute when it comes to bargaining. And she's going to discuss that and discuss where we are procedurally. And I'm going to launch a separate poll. So Colleen, can you take it away, please?
Okay. Doug, thanks for the hyperbole. In any event, but I will, obviously accept all the praise you can give me, but it's false. But in any event, so we received management's proposal sometime around, I'd say April. And we filed a demand to bargain, and then Chris Santoro proceeded to go on a 2-week vacation to Italy, so everything stalled. We then proposed ground rules. It took 3 weeks for management to get back to us, and we finally agreed to ground rules about 2 weeks ago. But then again, Chris Santoro went to Amsterdam for 2 weeks, so everything was stalled. And so one of the provisions, this year's ground rules require that we bargain in person, which is what we wanted, because things are much more efficient bargaining in person. Doing it, we tried it several years over Teams. It just doesn't work. With complex bargaining, you've got to be in the room with your own group, your own team, and then of course with the other team. So we agreed to bargain in person. Now, several of the provisions of the ground rules have not been fulfilled. So one of them is that we need to get a list of all the impacted employees so we can communicate with them, because we need to get feedback and tell you what is happening. And we can't do that if we don't know who's impacted by these changes. And again, we're remote. We don't know every single person, every single attorney at the board. So we need management to tell us. And if you're a member, we'll know about you, but not if you're not a member. So in any event, we need to do that. They also need to give us a color printer, which they haven't done, and other equipment. And they need to respond to some requests for information, which they have only done partially. They haven't done, and those are ULPs. And so all those things can stall bargaining. One interesting thing we have this year is that we're going to be bargaining with the help of a mediator. And that should help bring down the tone. We found that bargaining with management at the board, not other places, but only the board, has been extremely difficult. It's contentious. And that's because the current management team has a very dim view of our bargaining unit and the attorneys. And they focus on the few that maybe aren't, in their view, up to snuff, instead of looking at the 98% who are doing everything properly and in accordance with expectations. So in any event, we are going to start. We have a meeting with a mediator on Monday, and then we'll see where to proceed. But we can't really proceed yet because management has to fulfill certain obligations first before we start bargaining. Management has threatened to implement without completing bargaining, which of course they can't do. But unfortunately, if they act illegally, we have to comply and then grieve, and they have to live with the consequences later, when they'll have to maybe make everybody fully successful if they weren't, or whatever. But so one good thing about bargaining in person is that we did ground rules very quickly. Last year, bargaining ground to a halt because their chief negotiator, who was Tom Rodriguez, refused to bargain in person. That's what we wanted. We said we want to bargain in person. For the 2 previous years, bargaining didn't work. We want to bargain in person to get this done. He said no, no, no. And then it was October. So, if he says it's the union, whatever, we just want to bargain in person, which is our absolute right. And he does not have a right to be in Boston. He's an SCS. He signed some mobility agreement. He does not have a right to be in Boston, but he refused to come to DC or fly us up to Boston for in-person bargaining. So that's what happened last year. It wasn't the union that slowed things down. It was management. So in any event, we want to get the best deal possible for you. We think that bargaining with a mediator might be better because I think the mediator the management might be more responsive to the mediator conveying information than us, because it's a third party, and not the dreaded union. But basically, they shouldn't. The law says they can't implement until we complete the bargaining process. And so we're hoping to get a good deal, as good a deal as possible. But of course, we don't have as many rights as you would do in, say, private sector bargaining. We can't say like, no or whatever. We have to work within the parameters of what they gave us. But we're going to try to get as good a deal as possible. We always have done that. And so the next step is meeting with a mediator on Monday, and then we'll kind of see procedurally how things go. But the fact that they have Tracy Westner on the team, who's done the job for a while, might help, because the problem with Santoro is that he's never done this job. He's the chief negotiator now. He's never done this work. He's a bean counter, but he's never done this work. So it's hard to explain to him why we want certain things that we want, because he thinks, well, what's the problem? Well, we've done this work. We know what the issues are. And so it's going to be helpful to have her on the opposing team, hopefully, and also to have a mediator who can maybe help us navigate the situation with management. So again, like, please check the website for the standards and give us any suggestions you can. In terms of, I saw something in the chat, somebody said, get rid of the mini teams. That's not within our purview. Management has a right to determine organizational structure, but still, any suggestions you have, especially with procedures and appropriate arrangements, different ideas for proration, for example, or anything like that, or with quality, if you get a bad mark, what we can do to alleviate that. Like, maybe one proposal we're thinking of is having then maybe some other anonymous VLJ review the same case. Things like that would be very helpful to us in formulating proposals for management to get us the best deal possible under the circumstances that we have now. So again, please contact us with ideas and anything that else, any kind of comment you have. You can email or just call and tell us, but we want to hear from you. So that's all I have. And back to Doug.
Oh, thanks, Colony. Appreciate it. Yes, I just want to kind of add to what Colony said. Is we had to negotiate, and this did not impact the Board of Veterans Appeals, but VA Central Office, the return to 50%, which was very unpopular with employees. And we sat down with management's negotiating team from the Office of Labor Management Relations, and we sat down for several months. And it was our position that we don't have to bargain this, because we already have a provision. And Secretary McDonough cannot limit telework to 50%. But we met with them for several months and we discussed this. And it was a very actually warm relationship, where at the end we knew we weren't going to see each other. It was kind of sad, and we wish each other the best, and we still communicate. And it was very collegial. And I'd like to have stewards from the board go work at other places and represent employees over at VBA, VA Central Office, OINT, to see that it's not always like the Board of Veterans Appeals. And I don't, these are not bad people in management. I don't think they're bad people. I think they're very decent people. And I like most all of them. Like, if I went to a party, a cocktail party, I'd probably enjoy talking to any one of them. They're interesting in many respects, the things they've done with their careers and their personal lives. We just vehemently disagree on how things should be run and how they treat employees. And frankly, I wouldn't want to be in their shoes. It's very difficult, the job they're given. Like, hey, Congress kind of screwed a lot of things up with the AMA, and they could clean up a lot of the laws where make this a much easier process, but they don't. And it's our system. It's very complicated, and they're kind of left with a mess. I do think it takes a special kind of person to stand up to Congress and the secretary and say, you know what, we can't do this. This is not right. We have de novo review that's mandated by statute, and the current chairman does not have that ability whatsoever. And everybody else has to follow orders. So it's a very difficult environment for them. But we will continue to do, and as Colleen said, we cannot negotiate the content of your performance standards. We can't say, we don't like this number 156. We want you to count issues. We don't have, that's an exclusive management right. We can only negotiate and propose procedures, appropriate arrangements. What is that? Well, we want proration for this. We want proration for that. And if you think about it, all this proration, and people don't even ask for all of it because it's such a pain in the ass to do this administratively. They don't like it, and it could be simpler. It could be much easier. Just lower the quota. When I started in 1997, we didn't have a quota, and I started the same day as Tom O'Shea, who's now a VLJ, and we knew they wanted a certain number out of us a week, and we really strive for that. And there was like a culture of trying to please the boss because we respected the boss, and there was mutual respect there. And I don't think if they got rid of the quota, I don't know what would happen these days. I really don't. We tried it briefly. Productivity went way down. However, back then they did not prorate for leave. So people weren't taking vacations, and all of a sudden they were free to take vacations. And I think that was really the variable. But whenever you have a quota, it's usually not a good thing for any organization, any enterprise. Quotas are kind of frowned upon, and they cause a lot more problems than they solve. So this is what we're stuck with, and we understand it's a lot of pressure on us. We understand that whatever deal we get, it may determine who gets fired, who doesn't get fired. It may determine who gets promoted. It may determine who gets bonuses. And we also understand that you can be in a certain situation and maybe have your job threatened and be on a PIP, where if you were in another situation, you could be getting bonuses and all kinds of different things. And there's not a lot of parity or consistency at the Board of Veterans Appeals. And there never has been, there never will be. But the system in place now has gotten much worse. We've grown very quickly. And we're going to try to do our best. We are focusing most of our resources on this. I was heartened to see that most of you, 92% are dues paying members. 4% are not, but are interested. That comes to 6 people. And we would love to see those 6 people join. And there's 4%, 5 people said no, they're not interested. I understand that somewhat, but we do spend a lot of resources on the Board of Veterans Appeals. The dues are under $20 a pay period. And a lot of you who are 14s, it seems like something that would be something you can afford. The benefit you're getting is tremendous because there's a lot of locals, they don't even bargain. Management rolls out standards and they're just sitting around for whatever reason. And we hear these stories, but Local 17, we're incredibly effective because we do have a lot of members, and the money we get, we invest it back into you. And everybody that I mentioned has been to extensive training on the statute and how to bargain in good faith. And whenever we sit down with the other side, I know that our team is more knowledgeable and has more skills than the other side. It's always like that. And it's actually recognized throughout the Federation. And we are noted. And that's the team that you guys have elected. And it's also your membership that supports us, that we're able to do this. And we're only as strong as our membership. And I think we've probably doubled our size since Colleen and I were elected in 2016. And it's definitely shown. And the team we have is the best I've seen since I've been around for 12 years. It's just unbelievable, the dedication that everybody has. So I want to thank everybody for coming. And I know I was trying to keep this actually 45 minutes. So we're at 12:46. And try to wait until Monday to see what's on the website. And if you do have a question, let me know. But I know my email just blows up. I'll try to get to everybody's question within 24 hours and provide an answer. I just ask you to be patient. So,
Doug, before you go,
yes.
did you want to mention the other new element that they're proposing?
No, they're mentioning some funky element that's it seems like difficult to get. It's not a critical one, so you can't get fired, but it's going to make it a little more difficult for people to get an overall outstanding rating. And we limited it to these 3 because these are the 3 that are the most impactful. But we are going to put all the proposed elements, all the proposed performance standards that we receive. We're going to put those on our website. And our web guy, is also works for VA full time. I don't mention his name just to protect him, but he gets to it when he gets to it. He's usually very responsive, and it's funny. He works at Vaco. He feels terrible for you guys because he sees all the stuff that we post, and he's 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 an incredible resource. We pay him. He does this on nights and weekends. So again, your dues are. We just had our national convention in Las Vegas. There's 1,000 AFG locals in the country, not just the Department of Veterans Affairs, but every government agency just about. And our website won 3 awards. I don't know how many awards there were given, like maybe 5. So it's not. We realize it's not what we do, but how we communicate, so everybody knows what we're doing. And we have a better way of communicating. So thanks everybody for coming here. Thanks Colony, JR, and MB for giving the presentation. And we will keep everybody posted as usual. So enjoy your weekend.